Honorable Victor Oko-Jumbo and other members of the River State House of Assembly loyal to the Governor of River State, Siminialayi Fubara, said they have appealed the the Court of Appeal judgment that voided the State High Court decision that gave them power to serve as Speaker and members of the state legislature. Jumbo said they were already at the Supreme Court challenging the judgment of the Appeal Court delivered, which held that Justice Charles Wali of the State High Court lacked the jurisdiction to entertain the matter of the state legislature. The Court of Appeal on Thursday, in a suit filed by Amehule and others, declared the High Court order that barred them from parading as Speaker and lawmakers null and void. Jumbo, who disclosed this while addressing lawmakers during their plenary at the temporary facility used for legislative businesses in Port Harcourt on Friday, clarified that the action was necessitated by the fact that they strongly believe that the Court of Appeal erred in it when it held that the State High Court lacked jurisdiction to hear and determine the suits. Jumbo declared that he remained the authentic Speaker because there cannot be two houses of assembly in the state, reiterating that the seats of Honorable Martin Amehule and 24 other former lawmakers remained vacant as declared by the then Speaker, Honorable Edison Nehe, on 13th December 2023. He said that there cannot be two houses of assembly in River State, or indeed any state in Nigeria, and that the House of Assembly, with him as the Speaker, is the only House of Assembly in River State. He urged the Independent National Electoral Commission to promptly conduct a by-election and fill the vacant seats in River State House of Assembly. Let me start with you, Zoe. What is your reaction to this move and statement by Honorable Oko-Jumbo?
Well, I want to believe that the states, the governor has a very competent Attorney General. I know that the Attorney General is very competent. He has been in the field. He's a son. So I want to believe that the government have good advisors, competent advisors, to advise them on legal matters. However, looking at this case, in my opinion, there is no need for Oko-Jumbo and the rest of them to go to the Supreme Court. It's not everything. Look, River State is becoming very notorious. You know, River State has been projected in a notorious and a state that is now being always going to the courts for any little thing. The judgment that was delivered a few days ago by the appeal court has not changed anything. There is no cause for alarm. The Oko-Jumbo faction there's nothing threatening their position as Speaker and the legal members of the River State House of Assembly. The appeal court has only ruled that the State High Court does not have jurisdiction on matters that has to do with the State House of Assembly in terms of declaring the validity or otherwise of any member of the River State House of Assembly. That is the statement and the ruling of the courts. It doesn't affect the substantive matter. So there is, for me, except they just want to play the political game, keep going to court to prolong matters, I see nothing threatening the Oko-Jumbo's speakership and his members in the House of Assembly for him to begin to move to the courts. They would have leave it at that point, and so that the Amehule faction can still go to the Federal High Court, just as the appeal court have said. They are the people that should be pursuing the court, not Oko-Jumbo, because by virtue of that judgment, to the best of my knowledge, nothing is at stake. His office is not threatened. and nothing is disputing the fact that he is the legal speaker of the House. Mind you, Oko-Jumbo came to be speaker drawing from the vacancy that was created by A.E. Edison's speakership, which at that material time was legal and the constitutionally recognized speakership of the Rivers State House of Assembly. So most of the time, when one begins to wonder, I still believe that they have the rightful and competent legal advisors. But in my opinion, in this particular judgment of the appeal court, there was no need for the Oko-Jumbo faction to begin to head to the Supreme Court. It's all politics, or I don't know what to call it, but that they would have just stayed put, carry out their function as the members of the Rivers State House of Assembly until the Amewula faction, you can see after the celebration on social media and everything, they have not done anything because they know the implication of the judgment. So that is my immediate reaction to that action by Oko-Jumbo by going to the Supreme Court.
All right, we'll still come back to certain concerns you have raised when you were making your statement. But first of all, let me hear from Honorable Don. What is your take on this matter?
Anyway, sir, good morning. You see, I've listened to my friend and brother here, and I think I had to quickly rebut certain insinuations. It is not the Amewule faction that needs to approach the Federal High Court. If you are in tandem with the orders or the judgment of the Court of Appeal as delivered on the 5th day of this month, you would have realized that the court, first in their first order, said the appeal has merit. That's number one. Number two, the court held that the lower court, that is the trial court, that gave those interlocutory orders. Mind you, I have to make it clear that at the higher court, the matter of Oko-Jumbo and his clique were still ongoing. The matter were still ongoing. They were not fully determined. So what the Amewule faction, of the assembly was doing was to challenge the interlocutory orders that was made by Justice Wale. Now, in order 2, in the enrolled order of that judgment, order 2 made it clear that the trial court, that was the court of the Justice Wale court, they were not supposed to entertain the matter in the first place, considering section 272(3) of the Constitution of the Federal Republic of Nigeria as amended. I am sure they were aloof of that provision before going to the trial court. So the Court of Appeal voided the entire proceeding, and whatever determination, judgment, orders, or rulings that may have been gotten therefrom. And the third order, the court said the parties should return to the status quo ante bellum. That is where they were before the matter went to the trial court. That is the High Court of Rivers State. And further in that judgment, the court held that before now, there was no contention of the speakership of Right Honorable Martin Chike Amewule. Hence, it was not an issue at all. So, the issue of speakership, who is the right speaker, or whether they have defected or not, has been given a clear determination. The Court of Appeal have laid those issues to rest. And by implication, it would mean that everything that the House of Assembly members did, the 27 House of Assembly members did, were right in the eyes of the law. It's just like when the trial court gave them a ruling, and then they were all happy over the place and said everything that these other people did was wrong. This is the same position. So now that the Court of Appeal have laid the issue to rest, it said status quo ante bellum. It means where the parties were originally before the matter went to the trial court. So if they hadn't had an issue, why would they be going to the Supreme Court? That's even the question we should ask ourselves. See, it's not even just going to the Supreme Court. What is your claim? what are your grounds for going to the Supreme Court? See, that judgment, if you read the entire judgment, I pray when the CTC copies will be made available to the entire public, you will be able to see. If you be able to read the entire, you will see that the Court of Appeal took time. They didn't rush it. That was why it was, Court of Appeal, when they were taking time to determine each issues that was before the court. So they didn't rush it. So when the Oko-Jumbo faction has said, they didn't say Amewule is the speaker, it's a misconception of the judgment. Because what the Court of Appeal said was that, one, the speakership of Chike Martin Amewule was not in contention. Before now, it was not even an issue. They did not even raise it as an issue. Number two was that parties should return to status quo ante bellum. And that three, the court technically killed the woman and said the entire proceeding, including every other judgment or rulings that arose from the proceedings of the State High Court were void. And it remains illegal and void. And so once the Superior Court has made that order, what else do you expect? It is a child who if somebody has failed the exam, he will start looking for the people who did not allow him to read. Say, this one was not allowing me to read. That's how I failed my exam. So what is here today is that as of today, the Court of Appeal have given mandate to Chike Martin Amewule and 27 lawmakers. And by implication, it will mean that everything they had done within the period remains legal until either court sets those items aside. That's the position of the law.
See, I would like to come in, yes.
Right.
While I will give it to my colleague that he is entitled to his own opinions, but it is worrisome being a legal practitioner. Probably these are the interpretation that is making the Martins Amewule and co to be celebrating on social media. All that he has said were not, look, they are simple language, simple English that were in the judgment. The Court of Appeal never and did not intend to touch the substantive matter.
Which was?
When you said the Court of Appeal never.
And never intend to.
What exactly
was? Remember, he said they went to, to challenge the interlocutory order. The Court of Appeal never made mention of anything with the with relation to the judgment was that the trial court, like he said, does not have jurisdiction as far as the House of Assembly members with regards to whether they are legal members or not of the Rivers State House of Assembly is concerned. The trial court does not have jurisdiction. That is a substantive judgment in that matter. They never. He is now interpreting by virtue of that statement. He's now giving several interpretations to that judgment. So what needs to be done now is for them to go to the court that has jurisdiction.
What were the interpretations that Honorable Dawn made that you disagree with, and you said that the Court of Appeal did not rule on? Can you bring them out one by one?
Yes, he's interpreting the fact that the appeal court ruled that the trial court or the lower court does not have jurisdiction. He is interpreting it to mean that by virtue of that judgment, that everything about the Oko-Jumbo's fashion has been nullified by the appeal court. I'm coming.
Did the ruling of the appeal court, did the judgment of the appeal court say otherwise?
Of course, he didn't attend to that matter. He did not attend to the substantive matter. If you have the judgment, let's look at it. The substantive matter is the interlocutory order that was given by the trial court.
On what?
Restraining or totally stopping the Amewule and his faction from parading themselves as members of the House of Assembly members, thus holding to the fact that their seats in the Rivers State House of Assembly has been declared vacant, has been declared by the former speaker, Edison, Right Honorable Edison. That is a substantive matter. So it was based on that the Oko-Jumbo, when he took over from the Edison leadership of the House went to the court to substantiate his position as the Speaker of the House. Went to the court.
Which court?
The trial court now.
Do you remember the judge?
I can't remember the
Justice Wale.
Justice Wale, thank you. Now gave that judgment.
Do you remember the judge that also ruled on Edison Eye's matter?
I don't remember the details of the names of
Justice Danaguko.
Yes,
so
but
I want you to be clear so you don't mix it up.
Okay, yes, but what I'm really emphasizing on are the issues at hand. So it's based on that the Oko-Jumbo faction went to court because these people are still parading themselves. They are still trying to cause crisis in the state. So for that reason, the Oko-Jumbo faction went to the trial court. The funny thing is, the matter is still before the court. It has not been adjudicated.
Which court?
It's still at the trial court. The substantive matter is still at the trial court before Amewuli and his faction went to the Wale court you're referring to now. Yes, where the matter is the substantive matter is before the Amewuli faction went to the appeal court, challenging the interlocutory order that was ordered. Okay, and that is where the appeal court now gave judgment that the trial court does not have jurisdiction based on the section he has quoted, section 272, that they don't have jurisdiction. So what is that return to status quo is talking about before they went to the appeal court? Is the fact that Edison have declared this House of Assembly members seat vacant, and there was a vacuum by virtue of the resignation of Edison, and which brought Oko-Jumbo to become Speaker. That is what they went to do. So having given judgment, the appeal court having given judgment that there is no jurisdiction for the trial court, is for them now to go to the rightful court that has jurisdiction on the matter. So don't interpret the appeal court judgment in a way that will confuse the
Can I respond to him? Because
you will respond to him, but we need to quickly go on a break. We'll be back shortly and continue.